Okay.
Good afternoon, Barrister.
Good
You are
afternoon,
live
ma'am.
with Umuchiukwu writers. Yeah. Today we learned that Mazinan the Kano's co-defendant, Benjamin Madubu, Raichi Mezie, David Nwawishi, Chidebere, Onwuziwe, we are in court earlier today, and the little report we got, we heard about the court being adjourned and so many other things. And as it is right now, so many Biafrans are still waiting and waiting for an update from you to actually know what happened and how the proceedings went. So Umuchiukwu writers are here to bring it live to all Biafrans wherever they are across the world, and I would like you to brief the world. Thank you.
Thank you so much, my brother Chiwendo, and my brother. You're welcome, Umuchiukwu writers. God bless you. Thank you for having me once again in your platform. Today, of course, you are aware that the charge filed against Raichi Mezie, Benjamin Madubu, David, and the Shidebere Onwudiwe was the charge was pending since 2015. 2016, 2017. They were jointly charged with the Mazinan before it was separated. So, and they came up today for hearing because they have been separated. So, Nandi, the Mazinan hasn't been discharged. So, their own came up today for hearing. However, before now, we have filed an application, notice of protection, challenging the jurisdiction of the court to hear the charge, to continue the trial, on the ground that the 3-count charge filed against them contains elements of alleged offenses that were allegedly committed outside the jurisdiction of the Federal Court of Abuja. So, as such, that we have to go back to where the allegations emanated from and where the alleged acts took place from. So, and it's a fundamental issue, also anchored on 11 portions of the law, like Section 45 of the Federal High Court Act, which is very clear on what will happen where a person, a citizen, is being accused of committing an offense in a division of a Federal High Court, or probably in a location outside the jurisdiction of the Federal High Court, sees of the case, sees of the matter. The law says the person must be taken back to where the alleged acts emanated from. Are you with me?
Yeah.
So, we don't actually want to go into the merit or otherwise of the allegations, because that should be the second bite we're going to have at the charge when it's eventually transferred. So, because the 3-count charge as constituted are not only bogus, 3-count charge as constituted are not only bogus, but empty and frivolous. In fact, as a matter of fact, I don't see any reason why they should be coming to court to defend that bogus charge. But as law-abiding citizens that will come in to ensure that it ends well. The application was taken today on the merits, adjourned to the 5th of September 2022, of 5th of December 2022 for ruling. So, and we are hopeful because this application is anchored on strong judicial authorities, like the Supreme Court in the case of Suleiman against FRN, which extends very compelling authority that has to do with the issue of criminal jurisdiction of Federal Court. So, in that case, even the trial commences in Federal Court Lagos on alleged acts that took place in Kwara State. Then they proceeded to full trial, and they were to judgment in Federal Court Lagos. From there, the Court of Appeal eventually to Supreme Court. Supreme Court declared the trial that took place in Federal Court and consequent hearing before the Court of Appeal Lagos State as exercise in futility, because they ought to have been charged before Federal Court Kwara Ilori Division, because of the fact that the alleged acts constituting the alleged offenses took place at Kwara State. So, which is very, very compelling on our own case, the issue of receiving information of a broadcast on a broadcast made in London, we are all the charge count one was specific that information was received at Enugu and Anambra. Barr in this case was arrested in Akwa Ibom State. The second offense he was being accused of committing is offense of importation of transmitter, which they found at Obolosizo. These are acts within the confines, within the jurisdiction of the High Court in Enugu and Anambra. I don't know what he's doing here. Chidebere Onwudiwe and David Nwabisi, we also accused of frivolous offense of making broadcasts from London. Tell me Chidebere Onwudiwe and Bright and David Nwabisi, even all of them, apart from them, Benjamin Madu, who has been in Russia, has David Nwabisi and Chidebere and the Bright, have they traveled to London before? Yeah? So tell me how they can make a broadcast from London and to consider offense in this country. That will tell you how frivolous and childish and empty the charge is. But without prejudice to the merit or otherwise of the charge, we are not talking about it now. We'll get to that bridge, we'll cross it. What we're talking about, what's our major preoccupation at this point is for the charge to be transferred, for the matter to be transferred to Anambra and Oka, Anambra and wherever the charge they preferred. So when we get to the bridge, we'll cross that part. So, all the 3 count charges standing today against them constitute elements and acts allegedly took place in Anambra and Enugu. That's all. So I wonder, I wonder what they're doing in Abuja here. There's no business coming to Abuja. So we should go there. We have Federal High Court there. We have Federal High Court in Abuja, in Oka. We have Federal High Court in Enugu. We also have Federal High Court in Port Harcourt and Akwa Ibom, if the case be. So it was a very robust argument that was taken today and adjourned for ruling. And we're optimistic, believing that the court will find merit on application and grant same, at least to save them the transport of coming to Abuja, this stress, the inconveniences, the security threats they are being exposed to by coming to Abuja. So whenever the matter is coming up, so when they have a convenient forum where they will go to take the charge to face the trial. So that's all. That's the purport of the essence of the application taken today. And we are hopeful that on 5th of December 2022 that something good will happen, because we operate within the ambit of law, and we have placed our facts and laws before the courts, awaiting the court to do the needful. So thank you so much.
Thank you very much. As we were saying, we heard about the application for transfer of case to the region where allegedly these crimes were committed, and what I would like you to explain to Biafrans is, for instance, if this application is granted as it's been fixed to be ruled on the 5th of December 2022, if this application is granted, does it mean that the whole case is going to start afresh again, or they're going to start from where it stopped here in Abuja?
Unfortunately,
because as you said earlier on, this case started ever since 2015. And since then, there have not been anything that is coming.
Procedurally, when a matter is transferred to a new judge, in this present case, if application is granted as prayed, and consequently transferred to either Anambra or Kafra High Court to start afresh for trial. The trial will commence in November. I want to call it over, starting afresh. So it means that all evidence given so far in the matter will start afresh. But of course, someone has given evidence in the matter sometime in 2017 or about. So, and to start afresh. So, and we have other strategies lined up towards resolving the issue, towards addressing the incompetence of the charge itself. We will not come to that now. So, which I may not be able to discuss here. So, but I can assure you that there will be good. There are robust strategies, legal strategies we are going to adopt to ensure that once the charge is taken into another jurisdiction, we address the competence or otherwise. Because the charge as it constitutes today is not disclosing any offense. It will shock you to note